To my left is Judge Carolyn Ellsworth. She's on our 11 o'clock time slot. She's currently the judge in District Court 5. District Court 5 handles both civil and criminal matters. They do not handle any family law type matters, however.
And the other one?
Then from our 11:30 time slot is Christine, and I'm sorry, please pronounce your last name. Guerci Nias. I'm going to call you Christine if that works. And Christine is running in District Court 8. District Court 8 is also a civil and criminal seat. And again, similar to District Court 5, it does not handle family law matters either. Carolyn, why have you decided to run for re-election in District Court 5 at this point in time? And Christine, you'll have an opportunity to answer that question as well.
Thank you. Well, as you know, I was appointed by the governor in 2011 to fill a vacancy in the court with the retirement of Judge Glass. And so I was appointed October 17th. I took the bench for Department 5. So that meant I had to run in the next general election, which was 2012. And I did run in that for retention to my seat and won by 75.4% of the vote. So I'm running to continue serving as a judge, serving our community, and I think doing a fine job in Department 5. I think that people saw that, and that's why I was reelected. I'd like to now have my own term of 6 years because I filled my term that I was appointed to and then elected to retain is up at the end of this year, and so I'm running for my own 6-year term.
Okay. And Christine, I'm sorry, before you answer, I forgot to do this earlier. Full disclosure, I have now only one pending criminal case in Department 5. Because of that, I will be participating in I'll be moderating the panel interviews, but I will not participate in the actual deliberations because that would be off-putting for everybody involved. But I do have one criminal case in front of Judge Ellsworth set for trial in later this fall. So I just want to make that clear to you. Assuming Mr. Horn comes in to interview, I will make that same disclosure. Christine, regarding you, I had said this earlier, I haven't appeared in a substantive capacity in front of Judge Smith for a couple years now. I did, interestingly enough, testify as a witness in front of him about a year ago from a former client, but I have no substantive cases in front of him and haven't for a significant period of time. So if that does change between now and when we release our endorsements, again, admittedly in a month, I certainly will do the same thing and not participate in those deliberations. Otherwise, since I don't really have any connections to that department, I will, in all probability, participate in those deliberations. Okay?
Okay, great.
That having been said, Christine, why have you decided to run for the seat in District Court 8?
I was looking at running as a district court judge. And when I was working for the city of Henderson, I was doing economic development and redevelopment in that city. And one of the things that I noticed is that companies were looking to relocate to Las Vegas or Henderson, they look at the school system, they look at the court system, they look at the quality of the judges. When I was looking at running for district court judge, it's something that had been thinking of. I looked to see what the quality of the judges were. And in Department 8, we can do better. This is a judge who has been on the bench for a fair piece of time, was in Justice Court, which is a lower court, for about 15 years. Now in his first term in District Court, been reversed about 30 times, has a number of reversals based on violations of people's constitutional rights. I've got all the cases on my website. When I looked at the RJ review the judges, he's only got a 48% retention rate. When you Google him, you come up with a number of unflattering articles. So I decided that was the person who I thought should be replaced and that we could do better.
Well, let's talk about the RJ. We've had that brought up today. Shockingly enough, the RJ rating systems. And we'll start with Christine and go to Carolyn next. What ideas do you have to make the RJ's rating process more transparent or perhaps a more accurate reflection of the job that judges are or will be doing? Are or have been doing.
When you have surveys, it's always an issue because if you ask people to put their names on the surveys, they tend to be more cautious about what they say because they're afraid of retribution or those types of things. However, when you have anonymous surveys, then you get people who feel free to take pot shots. So I would like to see it, some more specific questions, more comments, more specifics about when you're grading the judges as to why you're giving that particular grade, and then the option to put a name on it or not.
Okay, so removing the anonymous aspect of things.
But the potential for some anonymity, because I think that
Okay.
if you have a case in front of a judge and you're unhappy with his or her performance, you're not going to rate them low because you're going to then be afraid for some retribution. So I'd like to see the option for a name on there, but just a little more in depth as to the numbering and as to why you're giving a particular number.
Oh, okay. Carolyn.
Well, I served on the Clark County Bar Committee when the RJ did the poll in conjunction with the Clark County Bar, which was some years ago. The bar doesn't participate in that survey anymore, but when they did, I was the chair of that committee for 2 years, or 2 consecutive cycles where they endorsed. And so the problem that I saw and that we were trying to address was getting more participation. That's really only, the participation sadly has not gone up over the years, and that's been exacerbated by the fact that we have many more judges than we did then. So that means that the lawyers that are asked to participate are told they're not to vote in a race, or not a race, but for a judge or evaluate that judge unless they've actually appeared in that department and within the last 2 years. But there's nothing, of course, there's no gatekeeping. So for instance, I was actually sent a survey and asked to participate in this last one, and of course I didn't because it's an honor system, right, that they've put in place, and being an honorable character myself, I wouldn't have thought to go on and rate either myself or fellow judges that I wasn't appearing in front of. But so there is a problem with that. There's also a problem with bias on the survey process, and that was borne out by a professor who did an in-depth look at our judicial survey process here and wrote an academic article on that. She's a professor at UNLV. And what she found was that there was a bias. It may be an unconscious bias, but is a bias nonetheless. And Harvard University has done quite extensive research and shown that most of us do have an unconscious bias, even though knowing that helps. Knowing that we have it helps to address it. But that women and minorities suffer at least 10% lower rating just because they are women or minorities. And so those things have not really been addressed by the RJ survey or by the ABA, who has commented similarly on these types of judicial surveys. That being said, I look at it and I try and learn as much as I can from those surveys. The judges, if they want them, they can get all of the comments that were made that aren't even published to see what they are. It's difficult because sometimes they're very, I'm sorry to say, hateful comments sometimes, which is, I'm sure, why the RJ doesn't publish those, and one is surprised that we would see something like that from a group of professionals. But nonetheless, I steel myself and read them all to see what people are saying, to try and take something positive away from that and learn from that. I was evaluated right after I had to make a very tough decision in a very public case where 2 other judges recused themselves, one after he had already accepted the case and then didn't want to go forward with it. And so I had been on the bench all of, I think, a month at the time, and most of the negative comments that I got were about that hard decision. Judges don't take the bench to make lawyers happy. I mean, we'd be happy if they were happy, but we take the bench to make hard decisions and follow the law. And that's what I do. If you're a judge and you are not prepared to make hard decisions, you should find another occupation. If that means that someone won't support me because I did the right thing and made a hard decision, then so be it. But I'm going to continue to abide by my own moral compass and doing the right thing and abiding by the law.
I can inform the people on the dais. For the judicial surveys, I ranked about 30% of the judges, just because if I did not appear in front of you, I didn't rate you. So about 30%, maybe about a third of the judges. It took me about an hour to go through the entire process. So it is a rather lengthy survey. It is very in-depth, and it takes a while to write all those hateful comments about all the judges that I didn't like. So
it was interesting to note that. Thank you very much. That there's a big drop-off. You can vote for retain, not retain, but they want you to go through and evaluate every individual category. But many people don't do that. All they do is hit the retain or not retain. You can tell that by the numbers. So the numbers should all add up if they don't.
That's no fun. In for a penny. Next question. We'll start with Carolyn and go back to Christine. From your time, both in front of the bench and then behind it, from all of your experiences, what do you see as the greatest inefficiency in the courthouse? And assuming you are reelected or elected, in Christine's case, what do you plan to do to try and address that failing?
Well, of course, the court has a case management, active case management system in place, and with goals, which are goals to try and move cases in a certain amount of time. And so we're all trying to reach that goal. But you also have to understand, and I was a practicing lawyer for many years, 32 years, being a lawyer on the other side. And so there are times when cases are not ready for trial. Particularly in criminal cases, it's extremely important that the defense lawyers have adequate preparation time in representing their clients. They're protecting their constitutional rights. So you can't push someone into a trial when they are not ready to go. And so generally the delays that occur, frankly, they're certainly generally not because of, at least in my department, because of the court's calendar, because I try a lot of cases in my department. But it's very difficult. There are certain cases where there are only lawyers that are qualified, like capital cases. Only certain lawyers are qualified to handle those cases. They have crushing caseloads. That's certainly true of our public defender's office. And so all of those things work toward delaying the system when the lawyers need to continue a case. What I try and do is, when I see that there are problems that are not justified, I try and put those cases on calendar. So for instance, for post-conviction petitions for habeas relief, oftentimes I'll appoint counsel. There have been times when I've appointed counsel and asked for the briefing schedule and set a briefing schedule based upon the lawyers' schedules. And then those aren't adhered to, and I get stipulations, and I'll sign those if there's good cause to sign those. But I had one where I actually had to bring the lawyer in, show cause why a petition had not been filed in a year. And this is somebody who has a petition for habeas release that needs to be considered by the court. And so I'll take those types of steps to move things along. As far as on my civil calendar, I do tentative decisions on all of my civil cases. I also do them in capital cases to try and give the lawyers ahead of time on their motions, either a motion for summary judgment to dismiss, motions in limine, so they get my written tentative finding. Not that it's my finding, it's a tentative ruling, so that they can then use that to tailor their arguments when they come to court. What this does is it narrows the issues for the lawyers. They greatly appreciate it. At least that's what all of them tell me, because when I stopped doing it for a couple of months, actually someone recommended that I not do them, so I tried that, and it was met with howls of complaint by the bar, who are calling my chambers asking for their tentative rulings. So I do that, and then that enables a shorter time at the time the case is argued, and it saves the litigants money. Their lawyers aren't in court for as long. People aren't waiting through long calendars. My civil calendars rarely go over an hour, and many times much less time than that, because I try and, if I can get things off my calendar, if there's no opposition, there are things that don't require oral argument because there's no opposition, I take those off, and no one needs to come to court unnecessarily.
And Christine, your experiences as a, not only working for the city of Henderson, but you have experiences at, I believe you are currently a deputy attorney general.
I'm currently deputy attorney general, was with the attorney general's office about 8 years before I went to the city of Henderson. So,
based on that, what inefficiencies do you see in the court system, and how can you address those?
The inefficiencies I see as a litigant or appearing as an attorney before the court is you have some judges, and certainly not Judge Ellsworth, who are unprepared and don't read the pleadings that are given, don't research the law, so that you end up with oral arguments that go on and on because the judge is educating themselves as they go, or they just simply are unfamiliar with business transactions or real estate transactions. I've had some very complex cases and with some very complex law, and I've had some judges who just don't do the research ahead of time, just don't do the reading. So I think what needs to be done, particularly in some of the cases, in some of the courtrooms, is that we need the judges to actually read the pleadings that are filed, to have their clerks or whoever do the research so that they understand what is being argued, understand what are the points that they should be looking at, and then tailor their questioning so that we can curtail arguments and long-winded things that just go on and on that are unnecessary. I'd also like to see the attorneys be better prepared. Sometimes that we do have attorneys that are there that just don't know their case, so I would like to hold the attorneys accountable for being prepared and coming to court on time and being able to argue the cases that they're doing, and being ready for trial when they say they're going to be ready.
Okay. Mike? No question? Freddie?
Judge Ellsworth, on those inefficiencies that you were talking about, does that happens only here locally or in the state of Nevada, or also elsewhere? I mean, is it like a current thing that's happening?
Well, I don't know what's happening in other courts, because all I know is what's happening in the 8th Judicial District. And, I talked somewhat to my fellow judges about these things, because we do have, like I say, an active case management. I've tried to get my fellow judges to do written tentative decisions as well, but they don't want to do that. It's a lot of extra work, because you do have to be, and I try to send them out. I email them out to the lawyers. I try to get them out 2 days ahead, if I can, and if not, they're ready when they check in, and they have time then before court to read them. But like I say, it requires a lot of extra work, because I do a very thorough analysis of their case. So I'm issuing a written tentative ruling that may be 2 pages long, single-spaced, with a discussion of their cases. Oftentimes I read their cases. So it's something that I've taken on for myself, because as a litigant, I often wondered whether a judge had read my papers, and I'd be looking at them not really knowing whether they had. Some I felt confident, others not so much. And so I don't know whether other people or other districts are having problems. Obviously, some of the smaller rural districts don't have as many cases.
Okay. And Christine, you've had some experience in the federal system as well, as did
Right.
Carolyn back in the day when you were practicing. Do you see these same inefficiencies in the federal system that you described in the state system itself?
No, I think typically the federal judges tend to be better prepared. The people appearing before the federal judges tend to be better prepared, so that it appears in the federal court that things tend to move smoother and quicker, and the judges seem to understand more of what's being said to them. I also practiced in New York before I moved to Nevada. I've been in Nevada about 13 years, and in New York you had some of the same inefficiencies, but the court was much more aggressive. When I moved to Nevada, I found that it was much more collegial and kind of a nicer atmosphere in the courtrooms here, but in New York it's a very aggressive, very abrasive kind of practice. So you didn't tend to get people who tried to either pull one over on the judge or didn't know what they were doing. You were held very accountable for yourselves and for time frames, and judges didn't hesitate to let you know if there was a problem.
It's just the way they talk.
It's just the way we are, you know, it's just the way
You're
New
all
Yorkers are.
screaming all the time.
Yeah.
I just have one question for Christine. What year did you serve as our intern at City of Henderson?
I was at the City of Henderson from 2010 to 2013, and I was the interim for 9 months in 2011.
Can I just ask, what was your biggest accomplishments there?
At the City of Henderson, I had been recruited over to the City of Henderson to help them with their economic development and their real estate procedures. They had been kind of doing sort of an ad hoc kind of process. So what I did is went in and made standard forms for them and standardized the process, standardized when developers came in, what we did. We came up with a new process that we called a project agreement. So we had an initial project agreement before we got into any of the further agreements, so that we could set out what we were trying to accomplish, what the city was willing to do, what the developers were willing to do. I also worked with the city clerk's office because they needed to revamp their public records policy. Their public records policy was outdated, so I worked with them in establishing a standard fee charge for all of the things, a standard form. So I worked with the City of Henderson a lot in just accomplishing things that we could get things moved forward. They had been doing things kind of on the fly, and we tried to standardize a number of those processes.